our lawyer, intellectual property lawyer, takes a seat to explain to us this very bizarre conversation of Ghanaian musician Kwesi Arthur. Kwesi Arthur was on a record label. He's left the record label. He wants to do his own thing. He's looking for photographs of his own image. Record label says, no, it's not for you. It's for us. You pay us for us to give you your photograph. It's your photograph, but you pay us for us to do it. That is technical law. Why is it so? Welcome, our lawyer. Lawyer, good evening. Please tell us your name again.
Good evening, Paul. My name is Emmanuel Dute.
Okay. So give us the legal position. First of all, what was the contractual obligation of Kwesi Arthur during the time he signed onto the record label? Who is the record label? Is it local? Is it international? And what do they do?
The record label is a local record label.
Is it a PA2s?
Known as Ground Up Charlie.
Ground Up Charlie?
Yes.
Okay, who owns it?
Glenn Boateng.
Okay.
Yes.
Mr. Glenn Boateng is the one who owns it.
Absolutely,
okay.
Yes.
What do record labels do, by the way?
Record labels basically act as investment companies. They invest in the career of musical artists, and they invest in the promotion, the marketing, the distribution, and the monetizing of the assets of these artists so that they can also recoup from their investment and get returns on their investment.
So they do an initial investment all the time?
Absolutely.
They start up with money?
Yes.
To do this, to do that, to buy you this, to buy you that, to buy you that?
Yes.
And to fly you to this concert and all of that?
Yes.
So they are managing you?
They are managing you, yeah. For want of a better word.
What is the obligation between the artist and the label, the company there? What do you call it? The label company?
Yes, Ground Up.
Yeah.
So basically, the artist, as the talent, makes himself available as and when to engage in the recording of the music and whatever the label really expects of the artist. Now, the label would also provide the financial resources for the production of this music in the form of sound recording, the production, marketing, the distribution, and also the monetization of that particular music so that they can also make money and make profits of it. So the artist is basically supposed to present himself or make himself available doing studio recordings, go for interviews that are being hosted or that are being produced or financed by the label so that they can gain such publicity for their own musical career in that regard.
Okay, so in the case of Kwesi Arthur, how many songs did he do under this record label? Do you know?
I wouldn't know the exact number of songs, but he did quite a number of songs with the label.
And when they sign the contract, does it have an expiry date? Does it have a termination clause?
It does. Every contract actually has a duration or a term. So there's an expiry date for the contract, and afterwards there's also some termination clauses in the contract where any of the parties could evoke if any of the preconditions for terminating the contract actually comes up. I mean, any of the parties could evoke them.
Okay, so and at some point in this story, Kwesi Arthur left the record label.
Yes, at
officially.
Some point in time.
He wasn't dismissed. He terminated.
Yes, he terminated.
So the termination was at his instance.
Absolutely.
Okay, and then what happened?
When he terminated, subsequently he decided to come up with a new project. And in the course of coming up with a new project, he sought to promote the project. So he had an agreement with an entity that monetizes music known as Even. And he attached some footages that were produced while he was under the label of Ground Up.
Footage means videos.
It could be videos or pictures.
Okay.
For promotional activities of the particular project.
So maybe he took a photograph with the Independence Square background, for instance. Yes. And he was jumping up as they do these days. So the camera takes him up. They do a drone shot of him. So he does a photo shoot around the Independence Arc, wearing different clothes kind of thing.
Yes.
And this product belongs to who?
To the label, because the label produced those footages. The label financed or provided the funds for the production of those footages. So it's not just about you being in your room or anywhere to take a picture. It's not about image rights per se. The dispute is centered on using specific footages that were produced by the label while he was under the label for his new project or to promote his new project.
Has he already tried to use it, or he's asked them to give him those photos, and that's what brought about this legal tussle?
So according to the lawyer for the label, they noticed that he tried to use it. And so they sent a correspondence via an email to him to desist from the further usage of it and from the unauthorized exploitation of those assets. And so I think the entity that monetizes his assets, which is Even, reached out to the label and also reached out to Kwesi Arthur to inform him that this is what the label is seeking to do. They are seeking to contest the further usage of these footages, and that is why these issues came up. So at the moment, Kwesi Arthur made a publication on his Instagram, I think on the 22nd of January 2026, indicating that the label claimed that they own his image and his likeness, and as a result of that, for him to be able to use his own image and likeness, he needs to pay a sum of $150,000 to them before he can get a clearance to use them.
How are you going to explain this to normal people? I mean, it's very so technical law. Even for educated Ghanaians, a person's own image, my own photograph. You tell me that my photograph belongs to you because you are the record label owner, and you can use that photograph, but I cannot use it. Is it a sort of oversight from Kwesi Arthur's lawyers looking in detail at the contract that he signed with the record label? Is that where the problem is, or all record label contracts are like that?
To answer this question, Paul, I need to make a distinction between what constitutes image and what constitutes likeness. Image.
Second one is what? Image or likeness?
Likeness.
Likeness, okay.
Image is basically, in law, the visual representation of a person. And so it takes into consideration the photograph, the video recording of the person, and sometimes even AI-generated images of the person in this current dispensation. Whereas likeness refers to anything about the person that makes the person recognizable. And so under a typical artist label agreement, there is a clause, a typical clause, which is a default clause termed as grant of rights. And under that clause, what it stipulates is that the artist agrees to grant the rights to the label for the label to use his image and his likeness to produce some form of works known as commissioned works for the promotion of their own activity in the quest to monetize the assets that the artists have collaborated to produce with the label. And so under normal circumstances, because the label is the one that has paid or made financial resources available for the production of these footages or this image or these videos for the purposes of monetizing or commercializing the asset, it belongs to the label. So I think what happened was that, and this is what I would just indicate to most artists out there, that there is actually the necessity, it is very expedient for most artists to involve lawyers to review the contracts extensively, because there are different kinds of label agreements. And I think there are some clauses that most often than not, these artists may term as unfair, but most often than not, they do not contest the unfavorable clauses up until probably the music has gone viral and they've made a lot of streams out of it. That is when they come back to actually indicate that these clauses are unfair. But under normal circumstances, business is business. The label would stick to the terms of the contract strictly, and at the end of the day, assert ownership over these particular assets that they have produced.
Fatih, what are people saying on the social media? Let's try and understand this as we wrap up on this part of the conversation. What are people saying? Because Fatih's sound, yes, okay. So, lawyer, the question is, what constitutes a breach? I'm guessing that it will have to be gleaned from the termination clauses in the contract. But what if somebody's asking what constitutes a breach? What do you tell the person?
Yes, Paul. Basically, like you just stated, it has to be gleaned from the contract itself, the express wording of the contract, and most often than not, one of the primary conditions for terminating a contract under an artist and label contract is if royalties are not paid to the artist within a particular period of time. And so the artist can invoke that particular termination clause as a basis to terminate the contract. There are also instances whereby if the label does not release the album or the song at a particular duration, because the contract would provide the circumstances or the duration or the instances under which the label should release a particular song for the purposes of monetizing or commercializing that song in order to attract streams. If the label does not do so, the artist can also rely on such provisions to terminate the contract as such.
That's interesting. Fatih, already now, tell us some more. What are people saying?
All right. Also coming from Douglas, he says, I like how Paul is able to source brilliant young lawyers. This Emmanuel guy clearly knows his stuff. Isaac Mann has an opinion. He says a contract is a contract, and once you sign it, you are bound by its terms. If Kwesi Arthur was dissatisfied, the more prudent approach would have been to engage his management privately and seek a peaceful exit or renegotiation, rather than taking the matter to the public. Publicly escalating the issue has only complicated what could have been resolved behind closed doors. And lastly, coming from Dennis, he says, in a situation like Kwesi Arthur's, where a label played a major developmental role, how does the law balance fairness to the label with the artist, creative, and economic freedom?
Okay, what's your final advice, lawyer, as we wrap up on this segment? What's your final advice?
I would basically advise artists to involve lawyers, not just because I am a lawyer, but the music business is quite technical, basically because it's in tandem with intellectual property law. And there are a lot of nuances, associated with it. So lawyers must be involved.
Are we having these days, as part of the legal practice, people with a full intellectual property practice? That's the only thing they do. The way we have commercial practice, are we getting there where we have intellectual property practice?
Yes, we are.
So you would advocate for intellectual property courts?
Yes.
You would like the Chief Justice to create courts for intellectual property?
I would like to appeal someday that the Chief Justice should set up a specific court for intellectual property disputes, because there's a new area of legal practice that is really coming up. And I think along the line, concerning the development of the nation, the creative arts are going to be much included in the process. We see it in other countries, in other developed countries such as the United States, where intellectual property is very huge. And so once there is the involvement of a lot of persons in that space, there is the necessity for a specialized court in that regard to be set up for disputes to be settled in that regard.
Oh, yeah, thank you very much. Thank you very much.